it is very, very clear that Abhishek Manu Singhvi says even in the Rabia case, let the speaker decide. Even if he decides wrongly, the court can only intervene once the final decision has been taken.
Right, and that's exactly what Nalini has those updates. Then Nalini, over to you. Abhishek Manu Singhvi arguing.
Yes, Nabila, the arguments on behalf of Abhishek Manu Singhvi, who is appearing for the Uddhav faction as well as the Maharashtra government, have begun, and he is relying on the landmark 1992 judgment of Kyoto Holohan, which is specifically on the issue of judicial interference in the matters of anti-defection law and the 10th schedule. And what he is stating is that the 1992 judgment clearly states that even if a speaker has taken a wrong decision, first you have to wait for him to take a final decision, and only that final decision can be subject to judicial review before a court of law. Till the time a final decision on the disqualification is not taken by the speaker, there is no jurisdiction of any court in accordance with the 10th schedule to interfere in these matters and pass any orders regarding this entire issue. At the same time, interestingly, what Abhishek Manu Singhvi is also stating is that once the speaker goes ahead and takes the decision, then that of course can be challenged before a court of law, but first the chance ought to be given to him to take a final decision in this matter. He's also gone ahead and said that there are some extraordinary cases in which coming to the Supreme Court directly is allowed, but this case is not one of them. There is no locus, there is no reasoning as to why the Shinde faction has approached the Supreme Court directly instead of first approaching either the Deputy Speaker or at least the Bombay High Court. And because they've approached the Supreme Court directly, the Supreme Court at this point should not indulge this matter any further. They should wait until the Speaker, the Deputy Speaker in this case, takes a final decision on the disqualification of these MLAs, and then the Supreme Court or any court of law can decide as to whether or not that disqualification was valid. Abhishek Manu Singhvi has also gone ahead and said that there will be certain points that he will be making regarding this entire aspect, bringing forth some facts which have not been brought forth so far, and there are going to be certain arguments that he is going to make which is going to be based on facts that even the speaker might not be aware of. Abhishek Manu Singhvi has also gone ahead and said that these disqualification proceedings that are going on with the speaker have still not been concluded. There has been no final order in this aspect, and because they are still pending, till the time these proceedings are concluded, there can be no challenge to them before a court of law. Like I told you, he is heavily relying on the landmark 1992 judgment to supplement his points. So we have legal precedents being cited from both sides, from Neeraj Kishan as well as Abhishek Manu Singhvi. But what remains to be seen is which point comes across to the bench as a valid stand in this entire matter. They have granted an urgent hearing of the case, which means that at least prima facie, it seems like there should be something that the Supreme Court should look into. But after hearing detailed arguments, to what extent are they going to indulge this matter, we'll only know once the hearing is completed and the orders have been passed.